Yeah, she needs to move down. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court Law Number 2. You have been asked to come to court today for what we call jury duty. You will be examined for inclusion on a criminal case. Our courtroom hours normally vary from 9 a.m. to 5 p.m. Whether you are selected as a juror in this case or not, you are serving a significant service which only free people can perform. If you are selected for inclusion on this jury, this case will be tried expeditiously, consistent with justice, which require careful, impartial consideration and a correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate for recess, for lunch, and at night. Before I go any further, I must administer to you one of two administrative duties. That is, I must administer to you one of two oaths. And I need each and every one of you to raise your right hand. And after I finish administering the first oath, please say, I do. Now, do each of you solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service qualifications as juror, so help you God? Okay, you may put your hands down. Now, ladies and gentlemen of the jury, the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on this jury, the case would be retried and you will be held in contempt of court and placed in the Jefferson County Jail up to 180 days and given a fine up to $500. Now, the way I'm going to ask the questions is as follows. I'm going to ask a series of questions. And the last question I will ask, is anyone disqualified under the law? Now, when I ask the questions, I do not want you to answer the questions out loud, just answer them to yourself. And then when I get to the end and I ask, is anyone disqualified under the law? If you think that you may be disqualified under the law based on the way you answered one or more of the questions, just simply raise your right hand when I ask if there's anyone who think that they're disqualified under the law. Now, the first question, except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause before I ask this next question and just try to explain this to you. I'm obligated to ask this question by law. I'm not trying to interfere with your personal affairs, okay? This question is, are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is there anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your hand. Okay. And now the way we're going to do this, we'll call you up before the bench. I will turn my mic off and I will turn this noise device on so that no one on the panel will be able to hear our discussion. That's juror number 7, Michael Andrew Salyers. Okay, Mr. Salyers, would you please come forward? Either way. Now, Mr. Salyers, you're going to stand right here, and we're going to have everybody to come up before we get started. She has to set up, and you're going to speak in it. This is this is going to be a microphone. Okay. Just hold on. All right. You want to stand up here?
You're right.
Okay. You ready? Okay, your full name is Michael Andrew Salyers?
Yes.
So, Mr. Salyers, when I ask the question, is there anybody who feel like they may be disqualified under the law, you raise your hand?
Yes, sir.
Correct? Okay. Would you please state into the microphone, why do you think you may be disqualified?
One is not raised for voting.
You don't have to be a registered because you're qualified.
Oh,
So you're not actually registered, but you're qualified.
I qualified.
What?
And then,
Okay. And what else?
and then one more, I was arrested when I was 18, 19 for drinking and driving. I didn't know.
You were just arrested?
I got DWI. It was
Okay,
19.
disqualified.
Oh, I didn't know that. This is my first time.
Okay, this says invalid legal activity. Have you been, um, have you been convicted of a theft or any felony? It wasn't a felony, right? Yeah, but
But
Okay, now state, do you have any objection, defense, you have any objection? Okay, you can go sit back down. Thanks for coming. Okay, the court is back in session and cause number M 332-118, case of South State of Texas versus Lanisha Danae Matwire. Let the record reflect that Ms. Matwire is present in court with her attorney, Attorney Wright Kimler. State is present with Assistant District Attorneys, Attorney Andrew Hewitt, and Attorney Haley Simmons. Let the record reflect that the panel is also present in the courtroom. And we let the record reflect that at this time, all members of the panel are qualified. Now we will move to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one or of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these next questions in the same manner that I asked the previous questions. That is, I'll ask each one individually. I want you to answer to yourself. And then when we get to the end, I'll ask if there's anyone here who would like to claim an exemption. If you would like to claim an exemption, then you will raise your right hand, and then we would ask that you will come up before the bench so we could discuss the matter more privately. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled in an actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the 3-year period preceding today's date? Or are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States Military Forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? If any of these exemptions apply to you and you do not desire to serve as a juror, just please raise your right hand. Let the record reflect that no one on the panel raised their right hand, so no one is claiming an exemption. Now I'll move to excuses. And with the excuses, I'm not going to ask you questions. I'll read some statements to let you know what the law is regarding exemptions. Excuses. And if you think that you would like to claim an excuse, you'll just simply raise your hand. A juror may be excused for observance of a religious holiday upon the completion of an application as required by Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Just please raise your right hand. Let the record reflect that no one on the panel is claiming an excuse. Okay. Now, ladies and gentlemen, everyone on the panel is qualified. No one is claiming an exemption and no one is claiming an excuse. And so now we will move to the voir dire phase of the trial. The previous phase that we were in was called impoundment. Let the record reflect that the court is convened in this case, clause number M332118, style the state of Texas versus Lanisha Dene Matoir. On today's date of April 23rd of 2024 at 2:26 p.m. on today's date. Let the reflect that the defendant, Ms. Matoir, is present in court. The defendant's attorney, Mr. Wright Kimmler, is present in court. The state assistant district attorneys, sitting first chair, Attorney Andrew Hubel, and sitting second chair, Attorney Haley Simmons. Again, ladies and gentlemen, good afternoon. You have been summoned to this court as a prospective juror in a criminal case. The defendant, Ms. Lanisha Dene Matoir, and she is represented by her attorney, Mr. Wright Kimmler. And again, the state is represented by assistant district attorneys, Attorney Andrew Hubel and Attorney Haley Simmons. Our court reporter today is Ms. Ada Christie. She will be taking down everything that's being said. So speak up when you are answering or asking questions. The bailiff today is Ms. Brenda Mosby. The defendant stands charged by information with the Class A misdemeanor offense of theft. Now, the punishment range for a Class A misdemeanor, if a person is convicted, is confinement in the Jefferson County Jail from a period of 0 days to 365 days, which is a year, a fine from $0 to $4,000, or the person can be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask that you will come up to the bench so that we can discuss the matter more privately. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready to proceed?
Ready, Your Honor.
Okay. Mr. Hubel, the panel is yours. Is 20 minutes enough?
Yes, Your Honor.
And I'll be keeping the time. You may proceed.
Good afternoon, everybody. As the screen says,
I'm Assistant District Attorney Andrew Buell, and my second chair is the Assistant District Attorney Gail Seven. Can everyone hear me clearly? Okay. So just to get some entry matters out of the way, we're at the stage of trial called voir dire. This term is often used interchangeably with jury selection, but the words voir dire have a meaning to speak true. And that's really all we're asking you to do whenever we're answering questions, asking questions. We're trying to determine who would be fair and impartial jurors in this case. So there are no wrong answers. We just need you to be sincere with us. And as Joe said, anything that you would need to discuss outside of the presence of your fellow jurors, we can do that after the voir dire phase is over. And the important thing to note is that jury selection is more of a deselection process, and that we look at the jury list after we've done this process and select individuals versus strike based on certain things we see. So the more you talk, the more you answer our questions, the more likely we hear something that would help us strike, selecting strike. Also, when answering questions, can you use your juror number if you remember it, because it'll make things easier for a court reporter to say that, to keep track of everyone. So judges introduced everybody already from defense and from the state. Does anyone in the panel know anyone personally? Whether it be from, yes, ma'am.
I know. Judge.
No, Ms. Hartfield, how do you know Judge Holmes?
I work with you. In Holmes County District.
And would that experience with Judge Holmes make you an impartial juror in this case? Okay, you could still be fair.
Yes.
Anyone else know anyone for the state, for the defense, or the judge? Another thing to discuss before getting into the actual definition of the offense is, has anyone here been victim of that? Or know anyone who has been? And by knowing anyone, I mean a family member or a close friend. Okay.
Yes.
Okay, so many of you have. Then I'll ask this at once. Do any of you believe that that experience would make you a fair report, would make you, sorry, let me reword that question. Despite the experience, can you all be fair and impartial, or do you think that it would affect your, like, decision-making as a juror?
I think it might affect.
Is that Ms. May?
Yes.
You remember 19? So you say that you think your experience with that might make you unfair or partial towards one side?
It would make me, really think about my own experience, what we.
Okay. After the state and the defense finish their case in chief, you'll be given a jury charge that has all the law contained in this case that help you come to a decision on this case. Are you saying that your experience would make you unable to follow that law?
I don't understand that. Well, I mean, what that.
After you've heard all the facts, you'd be given something called a jury charge. And in the jury charge, it has all the law that you need to make a decision based on this case and based on those facts. Does that make sense?
Yes, that makes.
Okay. So do you think that your past experience would make you unable to apply the facts that you decided to the law? In this case?
I don't know that it make me unable. I was just answering the question truthfully as far as having something like that happen in my life.
Okay. Now on the flip side of it, have you or someone that is a friend or close family member been accused of that? Okay. Now, onto the definition of the offense in this case. This is a class A theft case. The definition of theft is a person commits an offense if he unlawfully appropriates property with intent to deprive the owner of property. An offense of this section is a class A misdemeanor if the value of the property stolen is $750 or more, but less than $2,500. Now, within that definition, there are a couple of words to highlight. The meaning of appropriate, it can mean two things. It can either mean to bring about a transfer or purported transfer of title to or other non-possessory interest in property, whether to the actor or another. Now, can anyone think of what an example of that might look like in real life? Ms. Perez?
I'm not sure.
Anybody have any ideas?
You mean like the seller of a vehicle and the title?
That's a very good example. That's juror number 5, Ms. Fuller. I think that would definitely satisfy, the meaning of appropriate for, the first part of the definition. Alternatively, and probably the easier one to understand, is to acquire or otherwise exercise control over property other than real property. Anyone know what that would look like? Mr. Smith?
Well, I guess I would ask, what do you mean by other than real property?
Okay, let's say, real property is a legal term. It means land. So basically what we're looking at here is someone acquiring or otherwise exercising control over, some property that's not land, that is not theirs. Ms. Dirk?
On copyright laws. Would that qualify as not real property?
Yeah, that'd be pretty close to, the definition that matches number 1. As, but what generally satisfies me is a more, sort of a more physical thing. Like, say someone has a phone and you take it, that would more align with what number 2 is meaning. And then in either case, appropriation is unlawful if it's done without the effective consent of the owner. So in that same example that I just gave with the cell phone, if I gave permission to that person who took control over my cell phone to take control of my cell phone, that would not be considered appropriation. Does that, do those definitions make sense to everyone? Okay. So next, this is what I was talking about with Mr. Smith earlier, the definition of property. The first phase is real property, that's land. Then the second is tangible or intangible personal property, including anything separate from the land. Now, personal property, it can be any number of things. It can be the splitter, it can be a cell phone. Essentially, property, at least the tangible part of it, that you can hold and possess. Intangible would be closer to what Mr. Durr was suggesting earlier with, certain rights of copyright, stuff like that. And then we have the third basis, which is, documents including money that represent or embody something of value, so just stealing currency. And then value, to make it simple, it's either the fair market value of what's stolen at the time that it's stolen, or it's, if you can't ascertain that, then it's the cost to repair it to replace it at that time. Does that make sense? Okay. So looking at the elements that the state must prove beyond a reasonable doubt, It's that in Jefferson County, Texas, the defendant, on or above a certain date, unlawfully appropriated property with the intent to deprive the owner of that property, without effective consent of the owner. And then for the Class A theft, its value must be $750 or more, but less than 2,500. Does that make sense? So we've already talked about this a bit, but whenever you hear the word theft, what comes to your mind first, Mr. Sully?
Like it's something that don't belong to you.
So, Ms. Bowler, can you think of any common instances of theft, like common examples?
Sure. Someone steals your purse, someone steals your car.
And just like that purse snatcher, shoplifter, and the, like stealing one's car, that works. So why do we have these laws, that are against theft? Mr. Minshew?
Protect people's property so they don't have to worry about other things disappearing.
Can you think of any other reasons why we might have these laws? Mr. Salyers?
So people won't do it again.
So just to name a few reasons, and this isn't a local lens, protecting the property of citizens of Jefferson County, holding individuals who do take that property accountable, and disincentivizing individuals from stealing in our county. So, this is a poll question. If y'all could look at the question, which is it important for the state to prosecute these kinds of cases? It goes from 1 very important, 2 important, 3 somewhat important, 4 somewhat unimportant, 5 unimportant, and 6 very unimportant. I'm just going to quickly go down the rows, and if you can have your number ready whenever I get to you, just go ahead and say it. Ms. Perez?
My number is number 1 and I think number 2. It's important.
Okay, I see, you're juror number 1 and you're second. Okay, so for the purposes of this poll question, we can just say the number for your answer here. Mr. Smith?
Number 2.
Ms. Dirk?
1.
Mr. Tilley?
1.
Ms. Bowler? Mr. Minshew?
2.
Mr. Salyers?
1.
Ms. Hartsfield?
1.
Mr. Dowd?
1.
Mr. Nunley?
1.
Mr. Frankel?
1.
Ms. Bronson?
1.
Mr. Dent?
1.
Ms. Rosette?
1.
Ms. Sutton?
2.
Mr. Stone?
1.
Mr. Haldeman?
2.
Ms. Major?
1.
Ms. May?
1.
And Ms. Perez?
1.
Thank you. So state's burden in these cases is to prove the elements beyond a reasonable doubt, and if the state does so, you must vote guilty. If the state fails to do so, you must vote not guilty. Now, that burden of proof beyond a reasonable doubt, we can't give a definition of that for you. But it is established that it does not mean beyond all doubt. So, an example of this. Okay, so we have some puzzle pieces here. Can anybody say what this puzzle is of with those few pieces there? It's not enough there. There's a lot of reasonable doubt as to what that puzzle may end up being. Now, Ms. Hartsfield, can you tell me what that is? What that puzzle is of? Like you, oh, I'm sorry. That's okay. Can anyone see the puzzle from here? All right. So, Mr. Devlos, you can see it? Okay. And even though there's some pieces missing from the puzzle, you can tell that it's a pistol. Do you have any reasonable doubt that the image made in that puzzle is a pistol? Okay. So, like, even. And that's the idea of what a case looks like, especially with older cases. Certain pieces will be missing. Not everything will line up perfectly as the case is going along. But at the end of the case, once you've heard all the evidence, seen all the exhibits, it is up to the state to prove beyond a reasonable doubt.
Mr. Hill, you have 5 more minutes.
That the defendant committed the offense.
If you need some more time, just let me know.
So, Mr. Nunley, what kind of evidence do you think that you would want to see in a death case?
Evidence that the person that committed the offense committed the offense,
Okay, can you think of some examples real quick?
like video evidence, testimony.
Okay. Any other examples, Mr. Shangle?
There's no example to prove, the person actually obtained the property, that they actually have the property, or if that's whatever the case may
Okay.
be.
You want some kind of proof of possession?
Yes.
Okay. Now, going on to the issue of punishment, because that will be your decision in the second part of trial, should there be a guilty verdict. This is a class A misdemeanor, so as the judge was saying earlier, the punishment range is up to a year in jail and up to a $4,000 fine, or that confinement and fine. Defendant is also, subject to probation, if you so choose. Just a short bit on witness credibility. Ms. Bronson, how have you evaluated witnesses' credibility?
I would just listen to everything they have to say, and once they're done, some else.
Okay, so will you agree with me that that's essentially a skill that you use every day when talking to and interacting with other people?
Yeah.
So that would, you wouldn't give a witness any more credibility or any less credibility just from how they look or how they're employed?
No.
Okay. Does everyone agree with that? Bit on witness order, coordinating witnesses, is very hard work. Everyone leads a very busy life. But I assure you that at the end of the case, even though gathering witnesses and gathering a group of people just in general is kind of like herding cats, it will all make sense in the end. Just like the picture of this. Okay, so once again, these are the elements that the state has to prove beyond a reasonable doubt. In Jefferson County, Texas, the defendant on or about a certain date unlawfully appropriated the property of another with the intent to deprive the owner of that property without effective consent of that owner, and for it to be a class A misdemeanor, the value of that property is $750 or more, but less than $2,500. Now, the jury's duty in that case, looking at those elements, is that once you've heard the facts of the case, you're the finder of fact, you decide the facts of the case, you apply the facts to the law that's given to you in that charge that I was talking about earlier, and then follow the law in rendering a true verdict on the case. Is there anyone here who, for religious reasons or otherwise, thinks they cannot sit in judgment of another? Okay. Any questions for me at this point? It's the last time that we'll have an opportunity to talk to each other before the trial starts. All right, thank you. Justice, if you couldn't vote about each of you.
Representative.
Yes, you may.
Afternoon, ladies and gentlemen. Afternoon. The jury's decide facts. Mr. People just told the jury's decide facts on the PowerPoint. Do they decide facts?
They listen,
They listen, yeah,
make decisions on the other facts.
right. How many people have served on a criminal jury before? Mr. Davalos?
What kind of case was it?
Murder case.
When you listen to the murder case, well, let me ask you this, do you mind telling me, was it a convict, was it a guilty or not?
No.
Not. So there was reasonable doubt in the case, right? Does not guilty mean the person was innocent? No. What's the difference between not guilty and innocent?
Innocent, you know for sure that he didn't do it.
Right.
Guilty, just, you're not doing it.
There's a reasonable doubt, right? The jury's find people innocent. Mr. Dowlos, I congratulate you, the first person I ever had on a panel that's actually gotten in front. Do juries find people innocent? Mr. Tilley, do they find them innocent?
They found him not guilty.
Not guilty, like Mr. Dowlos said. So there's no certainty, right? Mr. Dowlos didn't decide the fact that the person didn't do it, right? You don't know 100%. You don't decide that. I would suggest to you, judge the fact. Right? You judge the facts, and at the end of the trial, you decide based on your judgment of what your evaluation of the evidence, I would say, what purport to be facts, whether the state's established beyond a reasonable doubt that all of the things that they're required to prove have been proven. And if they have been, then it's guilty. But if you have a reasonable doubt about one of those facts that were required to prove, then it's not guilty. Right? So does guilty mean 100% for sure somebody committed the offense? Major, does that mean 100% for sure with certainty that somebody did what the state says it did? No, right. How many people here think that there are actually people who have been convicted on a beyond a reasonable doubt standard that are actually innocent, right? There have been. And we know that through DNA evidence. Mr. Smith, what do you think? Raise your hand. They have been, right?
Yeah, I definitely think people are in jail that they're revisiting like DNA
Right.
evidence.
Well, prison, actually, yeah. And we know that through DNA, the miracle tool with modern forensics and forth. We'll see how we function with that. It's like the dark ages and they're trying to operate in some, that's how you think of the world, with criminal justice system before we had DNA. So the jury doesn't decide 100% either way. It's just, you do the best that you can, and the standard that you apply is proof beyond a reasonable doubt. Now, you would think that if something that important of a concept that Judge Holmes is going to instruct you what proof beyond a reasonable doubt is going to give you instruction to that effect. Is that what happens, Mr. Haldeman? Is that, do you know?
I don't know.
You don't know? Okay. But I guess I'll go back to you, Mr. Dowell, you started on the jury. Is that defined? Does the court give you an instruction about what the definition of proof beyond a reasonable doubt is?
I don't remember, it's been 6 years, but
Right. Does anybody who started on the jury remember? Do you get a definition?
I think it's
What do you get?
Well, no, I don't
No.
think I. Given.
And you served,
Yes,
you served on a criminal jury. What kind of jury was it? What kind of thing?
it was aggravated.
Assault?
Assault. Yeah.
So it's another felony. Was it Judge Stevens or Judge West, or was it a different county? Don't
Well,
remember.
it was years ago.
Okay. Well, do you remember the judge telling you what it wasn't, that it wasn't proof beyond all possible doubt?
Yes.
But he didn't tell you what it was. Here,
To my recollection, correct. I mean, it
they didn't
not
tell
be
you,
defined.
they didn't tell you what it was affirmatively, right? There used to be a definition that proof beyond a reasonable doubt, and this is like 20 years ago, but proof before the Court of Criminal Appeals threw it out. But proof beyond a reasonable doubt is doubt of such a convincing nature that you will be willing to rely and act upon without hesitation, and most important, beyond affairs. That used to be in the jury instructions. And I know that by heart because I've made many closing arguments quoting that to the jury. But that's not the law now. Each person who's on the jury has to decide for themselves how high the standard proof beyond a reasonable doubt is. Right, so if you're on the jury, you're not bound by any definition of proof beyond a reasonable doubt, other than it's not certainty, it's not proof beyond all possible doubt. How high of a standard do you think it should be, Mr. Murray, on evaluating the facts of the testimony that the state is putting forth to establish, how high of a standard?
Very high standards.
Why is that?
Someone's life, their future.
Right, their future, they're not gonna try to execute this disorder, it's not a guy.
No, but their future life is at stake. I think.
In the more abstract sense, right? What did Judge Holmes tell you here right before we started? He was going through the disqualifications from jury duty. What were the disqualifications? Do you remember? Yeah, if you've been convicted of theft, right? So right there, right out of the chute, if somebody's convicted of theft, they can never serve on jury. And there's other potentialities too. You can go to jail for a year and just you're a convicted thief, but you have ramifications for employment and whatever else. So would you do think that that's an important decision, whether somebody is convicted of theft or any other crime? And that frames for you the high of the standard of proof, right? This Bowler, is that right? What do you think? Proof beyond a reasonable doubt. Is that a high standard or not? Do you think?
Sure.
Why do you think so?
Because I think when you walk away, you have to live with the decision that you made for that person, that could, it could be a detriment, or it could be something that, you know, like a felony. Live with that.
If you want to be comfortable that you did the right thing. Sometimes it was called proof to a moral certainty. This is language that's in the law. It's kind of the idea that you can live with your decision. You're not second guessing your decision. Right? Why do we have juries decide whether or not somebody should be convicted of a crime? Why don't we just get, like Judge Holmes, a great judge, competent legal scholar, we could get maybe a couple more. We have to have an odd number of judges to vote, but maybe get 3 or 5 judges and just have a panel of judges and let them listen to the state's case and decide whether someone should be convicted. Just, I'm sorry, go ahead. Go ahead.
Well, there's listed in many counsel, and one could have biases, you know.
What if judges don't have, they're judges. They could be objective, they're trained legal scholars, they can evaluate the evidence, and get to the right result because they're experts. Why don't we let judges do that in this, civic? Why don't we let judges do it? Just get judges, it'd be a lot easier, y'all could be sitting at home watching TV or at work or doing whatever you do, mowing the grass. Wouldn't be up here on jury duty, listen to some Jake Lake lawyer talking to you about proof beyond a reasonable doubt. I mean, why don't we just let judges do it?
I think it's supposed to be a jury of your peers that are all bringing in their own perspectives and perceptions.
Maybe they get a more accurate result than the judges?
It should be jury driven.
Okay, what about you, Mr. Stone, what do you think? Why do we have juries instead of the panel?
Yeah, I would say that, you know, we're not judges, so we're out in the world doing normal everyday stuff. And so we kind of have a different perspective and experience than a judge.
What about the police? They're out in the world every day, right? Why don't we just let the police decide? I mean, we could just eliminate this whole process of trials and lawyers and just let the police decide. What do y'all think about? What do you think about that, Mr. Sal? What do you think about that? We're just gonna let the police decide.
Would work, I guess.
Well, it worked really well for the police.
Well, they're the one arrested them.
Sir?
They're the one arrested them. Would that be?
Would it be a lot more efficient if we just let the police decide who was locked up and convicted?
I don't think it'd be, that's fair.
Wouldn't be as fair, right? Democracy. Well, you could have the police run the democracy too. I think a democracy is safe. Yeah. Sometimes democracies devolve into that, you know. But I agree with you in principle. But where is, Mr. Nunley or Shank? Nunley's name. Where does the power rest? Well, let me back up one step. What's the result of convicting somebody in a criminal offense?
They're held accountable.
Punished, right?
Yes.
One punishment, which could be anywhere from a fine to execution in this state. Who has that power in our system? Who has the power to assert that and do that to somebody, to fix somebody's life in that way? Where does that power rest in?
It's supposed to be people.
Through what? Through the jury, right? And I would suggest that that's why we have juries. Even when you go to misdemeanor court, for misdemeanor theft case, you have a right to the jury. You have a right to the jury trial for a trial. That power rests with the people. It doesn't rest with the police. It doesn't rest with the judiciary. The district attorneys. And that's the purpose of being down here and going through this process, that y'all have to be convinced beyond a reasonable doubt before somebody can be convicted and punished. And so in light of that process, we're going through, now, how many of y'all think that we're actually selecting people off of the panel? Like I'm thinking, oh, he's good and she's good, I'm gonna pick them. Is that what's going on? Anybody? Mr. Nutter, what do you think?
So we're being disqualified.
Well, anyway, this qualification is like what Judge Holmes was talking about at the beginning. We're questioning you to try to determine which people we want to remove from the panel. I get to remove 3 and the state gets to remove for whatever reason. Well, but then there are some limitations to that. And then the first 6 people that you're left with who weren't struck from either side, as we say, not physically struck, but removed, that constitutes the jury. So in that sense, at least the people that make it on the jury are acceptable to both sides to the extent they didn't use their strikes on them. So hopefully, in theory, you get a fair and impartial jury. So for instance, Ms. May, when you say you did a victim of a theft, and that your impartiality might, and I appreciate your honesty, that you might not be able to be impartial, did you elaborate on that for me a little bit?
Our house was broken into
Okay,
while we were both at work. And things were taken and some damage was done and it was never solved.
never saw. Okay. So it was a burglary then, it wasn't just a theft.
I guess, yeah, however it's. No one was hurt, we were gone.
Right, it's still a felony, because it's your habitation, urban habitation is a felony. So do you think that translates just in general to anybody charged with a theft case, whether it's shoplifting or something else along those lines that doesn't involve a burglary? Do you think that you can be fair and impartial?
That's hard to answer.
For sure, maybe not on a burglary case, right? That involves a charge of burglary in a habitation, because that's exactly what happened to you. Or maybe burglary of a vehicle. Do you think that you could follow the court's instructions or not? Or would your bias, I mean, I hate to say bias or prejudice,
No,
that's
I
the
mean-
legal term.
Yeah, because you hate to use that word,
I know.
but I mean, it's up there. It's-
Right,
Yeah, it's,
I think a lot of people driving on intoxicated cases, when you have a jury, just like the jury on a DWI case, because there's so many people that have been
mhm.
injured by an intoxicated driver or a family member or low has been hurt, so it's hard to set that aside
Yeah,
as a draw. But that doesn't mean they may be great for a theft case, but they're not, just not for a DWI. You may be good for a DWI case, huh? This is just a good. Anybody else feel, and I know the Mr. Hedel asked this, like Ms. May, if you're a victim of a theft, this may be a difficult case where you maintain your impartiality on. Mr. Nolan, you're nodding your head, do you think?
If you have a bias about being robbed or like.
Right.
You probably won't look at a person who's been accused of being a thief. And
What about you personally?
I don't have a bias.
Okay.
I say that because of life experience I have been stolen from, but I've also know some of those people who have stolen and the reason behind.
Right.
So
I'll represent you in this case. This isn't a shoplifting case, it's kind of a run. I can't really get into the facts too much. But it is kind of an interesting fact situation. I anticipate, Mr. Hubel has put up, the PowerPoint, the elements of theft. And I don't have any quarrel with that. I think he's tracking the penal code, but the law that controls is going to come from Judge Holmes, not from me or Mr. Hubel. But this idea of intent with intent to deprive the owner of the farm. Right, we all understand theft. You steal something, you have to know that you're stealing, right? You're not, like if you pick up what you think is abandoned property, you're not intending to deprive anybody. So that idea of intent to deprive, I think is going to be an issue in this case. And you can evaluate that. Do you think that your impartiality would be effective to be able to evaluate the state's proof showing that the intent of this young lady is actually deprived to commit theft? You could be objective. Ms. May, what do you think? You can evaluate the actual intent. Fairly or it's still going on?
Mr. Kimberly, you have 5 more minutes.
Okay,
Said, I mean, just, I don't know until I hear.
Okay.
And so,
I got you.
yeah.
All right, anybody else feel like this, Mary, you can kind of, what do you think? What do you think?
Just.
Tired of listening to you?
Everything that's said.
Okay, you think you can be fair and impartial? All right. What about you, Mr. Ms. Shaw, you haven't said much. What do you think? You can, Mr. Sires, Mr. Renshaw, right?
Mentioned that.
Yeah.
We gotta be fair, I mean, evaluating what is presented for us and then making a decision based on it.
I'll represent you. This involves an automobile, car, vehicle. That affect anybody, step of a vehicle. How do you infer, like when we're talking about somebody's intent, and I'm about to be finished here, but intent, how do you know what somebody's intent or try to decide what somebody's intent is? Subjectively, the mental state, what's their intent? What do you look at? Their actions, right. Facts, surrounding it, and infer intent from facts, right? Does everybody think that they're capable of trying to look and see whether the state's met their burden on inferring intent to deprive, looking at the facts to see if those facts justify beyond a reasonable doubt this intent to deprive? I think really that's going to be the approach of the case. Okay. Ms. Harper, what do you think? You do that? Don't know, not sure. All right. Well, we're out of time. I thank y'all and look forward to this next meeting.
Okay, ladies and gentlemen, at this time, we're gonna ask that you follow the bailiff into the hallway. And we may call some of you back in for some follow-up questions. So at this time, the court will be in recess. You all can stand and follow the bailiff.
I think.
You can go out both doors.
Not into Bosco.
Oh, that door is locked?
Come on. That's-
So you have to go through the,
I apologize.
Let's just have 19 Josh recalls.
just wait there.
Ready to measure? You.
Jefferson County Court, Law number 2 is back in session. The court is in session and calls number M332118. The case is filed the state of Texas versus Lanisha Dene Matoir. Let the record reflect that Ms. Matoir is present in court with her attorney, Mr. Rife Kimmler. State is present with Assistant District Attorneys, Attorney Andrew Hubel and Attorney Haley Simmons. Let the record also reflect that the jury panel is now present and seated in the courtroom. Ladies and gentlemen of the panel, when your name is called by our court coordinator, Ms. Glenda Segur, you will please go to the jury box. There are some badges on the jury box. You will take one, have a seat in the jury box and pin it on it. Ms. Segur, would you please see?
Whitney Perez,
Whitney Perez,
Patrick Smith, Nathan Minshew, Michael Salyers, Kenneth Schenkel, Erica Bronson, Deb Diddy.
Okay, ladies and gentlemen of the jury, at this time, I must administer to you the second of the 2 oaths. I need each and every one of you to raise your right hand. And once I finish administering the oath, please say I do. Do you and each of you do solemnly swear in the case of the state of Texas versus Lanisha Dene Matoir, the defendant in this case, that you will a true verdict render according to the law and the evidence, so help you God? So you say I do. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions, interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorneys or witnesses, or objections to introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both sides, the state and the defense, have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a reasonable summation of the evidence and a reasonable deduction from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt an independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Do not take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The bailiff have provided to you badges identifying you as a juror. Please wear those badges at all times. Ladies and gentlemen of the panel, those of you who are not selected, we would like to thank you for taking time out from your busy schedules to be here this afternoon. I know that you were eager to serve as a juror in this case, but under the law, we only have a limited number of people that can serve as jurors in this case. Anytime that you're in the area, please feel free to come and have a seat in your courtroom. And the reason why I say that is because I know that when you came to the courthouse this afternoon, you looked over the top of the door and you saw my name, Terrence Holmes, as judge of County Court at Law number 2. And you probably said to yourself, oh, this is Judge Holmes' court. I'm in the right place. No, this is not my courtroom. This is your courtroom, because I'm only a servant, a public servant for the citizens of Jefferson County. And you being a citizen of Jefferson County, this is your courtroom. So anytime that you're in the area, please come and have a seat in your courtroom. The area that you're sitting in, we call that the peanut gallery. But it does not mean you could bring peanuts in here and eat, because this is not the Texas Roadhouse. But anytime you're in the area, please come and have a seat in your courtroom and see what goes on in Jefferson County. I like to tell people, actually, I like being in court more than I like watching television, because there are some interesting things that goes on in our county. And I love to serve the people. And the other thing is, anytime that you're in the area, we have some coffee that's prepared by the bailiff. If you want some coffee, we have some water, we can provide you with that. Now, your jury service has ended. And normally before I release the jury, I usually give everyone a handshake. However, you know, we still have COVID in our community. However, I will give everyone what I call an air handshake. So at this time, give you an air handshake, each and every one of you. Your jury service is concluded. The bailiff have some letters for you. You can take one of those letters. If you need an excuse or anything, you can just simply step across the hall to county court, to the district clerk's office. They have letters. They have any excuses if you need excuses, and you could turn in. We also would turn in the names of all those individuals. Everybody showed up today. It's a little unusual, but I'm glad everyone showed up. So at this time, again, I'd like to thank you for taking time out from your busy schedule on behalf of the citizens of Jefferson County and on behalf of the court, County Court at Law number 2. Thank you for coming. And Nancy, it's good seeing you again. We worked, I'm not going to say how long it was, but we worked together for many years. Matter of fact, I would say when you're starting off as a new attorney, the secretaries really prepare you and they know more law than you know. And so thank you for the training. All right, so at this time, you're in the hands of the bailiff. Everyone, please have a blessed day.
Thank you.
Oh, and just by the way, if you want to watch the trial, our trial will start at 1:30 on tomorrow. You can come in person or you can watch it on YouTube. Okay. Y'all have a blessed day. Now, Mr. Hubel, you're going to present your testimony at 1:30 on tomorrow. Is that correct?
That's correct.
Okay. So ladies and gentlemen of the jury, court is going to be in recess on this case until 1:30 tomorrow. Please show up on time and we would like to start promptly at 1:30. Now, sometimes I say that we like to start promptly. Sometimes we may have hearings outside of the presence of the jury. We don't necessarily know that until tomorrow. So if it happens, the bailiff will inform you while you are waiting outside. But if not, we'll try to get started at 1:30. I don't know how long our docket is tomorrow. Sometimes when I say the docket, we have hearings that start at 9 o'clock in the morning. And they go sometimes to 12, sometimes to 1, just like today. It went to about 1:45, something like that. So sometimes our hearings carry over into the afternoon. But if it doesn't happen, we're anticipating starting the trial at 1:30 on tomorrow. And make sure that you have your badges. Okay? All right. At this time, when the jury leaves the courtroom, everyone please stand. Please follow the bailiff. Okay, the court will be in recess.
You gotta let the alternate know he's an alternate, or is he doesn't know?
No, he doesn't know until
Oh,
they get ready to go to deliberate, so they can pay attention.
okay, I thought we let him know before, okay.
Okay, so at this time, the court will be in recess until 1:30.
See you tomorrow. Might be late.